Ed O'Callahan, partner at Clifford Chance Law Firm, former Assistant U.S. Attorney. What is the current state of ADA compliance?
Now that we have some history under the Act where cultural institutions and businesses have actually reached settlement agreements or made the reasonable accommodations that are required, that they really have been able to meet their requirements under the ADA under a relatively common sense approach to what they need to do to address some of the patrons that may have the various forms of disabilities.
What issues do institutions need to address?
The issues that they need to consider obviously are ones of structural issues. If it's a pre-existing structure under the ADA, they're going to have to make perhaps structural changes. Again, if it's a place of public accommodation, they'll have to make structural changes to comply. There's going to be a monetary component to what they do, but it really is a common sense approach to the accommodation. That's where we get the reasonable accommodation requirement. I think the program content issue is the more difficult one. However, again, I think that if you look at some of the cases that actually have been brought to settlement, you see that the Department of Justice, or if it's a local state enforcement of their own local laws, they're not trying to take over the program content of an institution. What they're trying to do is, frankly, cater to another potential pool or audience that wants to utilize and is for some reason attracted to that institution, right? Because of their existing program content. And so the reasonable accommodation in the program content is, again, something that, in my experience, the department has been willing to work with the institution on.
What does, quote, reasonable accommodations mean?
The definition of reasonable accommodation is that it is flexible within the construct of the institution about which you are talking. And so, there are some examples of some cases where the institutions were required to make significant changes. However, that is not, an across-the-board standard that is applied by the Department of Justice. It isn't the expectation that it's a, one-size-fits-all type of reasonable accommodation. Obviously, there is, as I said, there is some common sense application of this, so that a reasonable accommodation is something that is readily achievable within an institute of public accommodation. Those are all the legal phrases that are applied. And so what's readily achievable, so that you can say that the institution has made the reasonable accommodation, is necessarily going to have to vary from institution to institution.
What rights do individuals have under the ADA?
There are private rights of action under the ADA, where individuals can file their own complaints in federal court. And then what generally happens is, if it's a case that has merit to it, the local U.S. Attorney's Office will actually take up the case and perhaps pursue it on behalf or jointly with the individual who filed the original lawsuit. But I think that what the Department of Justice will say is, outside of that, there actually are, for example, in wheelchair access cases, there's a chart that does strictly provide for, depending on the amount of seats in a particular location, how many need to be handicap access and things like that. That's the easy, the easy case, right? When you get to the either deaf or hearing impaired, you get into issues of whether or not just providing a certain percentage of assistive listening devices is sufficient, or whether you have to provide for different areas where there would be loop systems put in place. So again, but I do think that what we've seen is that the Department of Justice has looked at it as on a case-by-case basis, and has made a determination of depending on what the institution is and what their capabilities are, what they're going to require them to do, such that they meet the reasonable accommodation standard under the ADA.
Copyright Art Beyond Sight, 2014.